are clients who have had relatively robust immigration strategies that involve petitioning for H-1B workers or H-2B workers or immigrant visas find it very endearing. And that's because these foreign nationals, they want to stay here. They want to stay here the rest of their lives for the most part. And in order to do that, they work their tail off and they follow the law. They don't drink and drive. They don't abuse their spouses. They don't do things that are illegal. And that's because they want that employer to take that next step, have a little bit more faith in me. And, it's one more ask, but I'm worth it.
Good morning, HR. I'm Mike Coffey, and this is the podcast where I talk to business leaders about bringing people together to create value for shareholders, customers, and the community. Please follow, rate, and review Good Morning HR wherever you get your podcast, Apple Podcasts, Stitcher, Spotify. You can also find us on Facebook, Instagram, YouTube, or at goodmorninghr.com. Despite concerns about a potential recession, U.S. employers are still hiring, or at least they're trying to. According to ADP, businesses created 208,000 new jobs in September. Unemployment was at 3.5%, and job openings remained above 10 million for the 14th straight month. As employers try to fill positions so that they can get products and services out the door, many are looking to bring labor into the United States from other countries. In March of this year, U.S. Citizenship and Immigration Services received a record 484,000 H-1B applications for the 2023 fiscal year. But H-1B visas, the largest category of non-permanent work visas, are capped at 85,000 annually, a number that has remained unchanged since 1990. That is 5.5 visa requests for each visa actually granted. Joining me to discuss the realities and technicalities of U.S. employment-based immigration is Kevin Lashus. Kevin is a partner with the Austin office of the national law firm Fisher Broyles. He is board certified in immigration and nationality law by the Texas Board of Legal Specialization. Prior to joining Fisher Broyles, Kevin was an assistant attorney general for the state of Texas and worked in the U.S. Department of Justice, where he advised special agents during national security investigations, criminal immigration prosecutions, and worksite enforcement actions. Welcome to Good Morning HR, Kevin.
Thanks so much, Mike. It's a pleasure to be here.
So, assume that I know nothing about employment-based immigration, which isn't a giant stretch. Give me just an overview of how that system works.
So, as you alluded to in your introduction, employers are desperate to find skilled talent wherever they can. And because we now live in a global environment, some of those assets happen to be foreign assets. And so employers who are relatively sophisticated are very eager to utilize U.S. immigration to bring in work authorized foreign nationals. Now, in the global kind of vision that we've got as a public policy initiative as it relates to global immigration, we want to be an exporter generally of democracy. And the easiest way for us to be an exporter of democracy is to offer an opportunity to educate foreign nationals here in the United States. So I live 3 blocks from the University of Texas. The University of Texas has a very robust international student services office that is not confined just to the public setting. Private institutions also have the opportunity to bring those foreign talent into the United States. And so what we generally do is we educate them about their potential occupations, but we also do so in a manner where we're trying to identify kind of those classic United States public policies. Freedom of press, freedom of expression, free economic movements, very little restrictions on trade, et cetera. And then we export that talent. Well, commonly, American employers fall in love with that foreign talent that's here and then engage them in an early opportunity out of college, and then are using the United States immigration system in order to kind of cultivate that relationship to allow those foreign nationals to remain with that employer for the long term, could potentially be towards lawful permanent residency, and more common than not, that permanent residency turns into citizenship.
But with so few, I mean, I think the total visas in any given year is like 140,000, right? So we've got all these. We're bringing people to the U.S. and educating them, letting them fall in love with America, and often at some level underwriting some part of their education, and certainly investing in them with our education system. And then a lot of them can't get a spot and have to go back to their country of origin. Why do you think we're at this 85,000 cap on H-1Bs, which is the most common for employment related visas after all these years since 1990, right?
In my opinion, the system's broken, and there's very little that Republicans and Democrats can agree upon. What they both can agree upon is that the immigration system is broken. There have been bipartisan approaches to fix the immigration system to alleviate exactly what you've identified, which is we're subsidizing public and private education to foreign nationals who want to stay in the United States and use that education that they've received to benefit employers, but we limit the amount of visas that are available. What Republicans would say, most Republicans, even the kind of farther right of the Republican Party, would say they are very big supporters of legal immigration. They understand, because they listen to the business community, that it is important for us to be able to have a process of identifying talent, cultivating that talent, and then holding on to that talent with a very robust immigration system. What the Democrats would say is, obviously, they're very supportive of business-based immigration, but they want a comprehensive reform to the immigration system, not just to limit it to businesses. What I would think, and Mike and I, you and I have worked together for the Texas Association of Business. I think most state chambers of commerce and even the local chambers of commerce would be very supportive of increasing that number of visas beyond 85,000. It could be 200,000. It could be 1 million visas. And in that way, we kind of could supplement the current workforce. Interestingly enough, upon your introduction, which is absolutely spot on, the Secretary of Labor testified before the House Ways and Means Committee about 8 weeks ago and identified that there are 12 million opportunities in the United States, and we just can't find the labor. Traditionally, business immigration has been about identifying what a prevailing wage is and then testing the local market to identify whether or not there is an able and willing United States worker that might be interested in that position. But even now, with so many job opportunities, even for those workers, for those employers that I represent to sponsor even permanent residents in immigrant visa, nobody is applying for those positions. And so I think the Biden administration is very aware and very cognizant that, the immigration, the inflation that you alluded to earlier, at least part of what's driving that inflation is an increase in labor cost. And the increase in labor cost it's all well. I mean, I think most employers would agree that we want our employees to live at a wage where they don't have to worry about housing and transportation costs and food. We want to give them an environment that is comforting to them, where they can be as productive as possible. But even in that, that increase in labor costs causes this more of a slide between employers, where your mid-level employees are finding it more advantageous to jump from one employer in a similar industry to another employer in that similar industry, just because of an incremental increase in that wage that they might benefit from. And as a advisor to these businesses, you and I both know that transaction cost of onboarding a new employee is significant. And so if we can minimize the number of employees that are jumping between employer, then we can kind of add value to the relationship that we've got with our clients, so that they can retain that talent that they've already spent all of this time, not only training, but onboarding.
And you mentioned prevailing wages, and we just, one of the big arguments has always been that immigration suppresses U.S. wages, but we've just been through 18 months of a real world test experiment, right? And the labor participation rate is going down, even though wages are going up. We're at 62%. It's been going down for 2 decades. And for whatever reason, especially in the young male cohort, people aren't participating in the workforce at the levels that they used to. And so even if with wages going up, people still aren't entering the workforce. And if I'm right, prevailing wages, you have to pay an H-1B visa employee at a higher rate than whatever prevailing wages. Is that right? Or is there's some formula for figuring that?
No, Mike, you got it absolutely correct. So whenever an employer is interested in sponsoring a foreign national to onboard in a work authorized visa category, and H-1B is the perfect example, they have to petition the Department of Labor to identify what the Department of Labor believes is the market wage for that occupation in that municipal location. So a market wage in Dallas, for example, for a software engineer may be lower than a market wage for the same engineer in Seattle, Portland, or San Francisco, for example. The reason why the Department of Labor asks employers to participate in wage surveys is exactly that. They want to collect that information to identify potentially what the market wage is, so that employers who are spending a premium to onboard foreign talent, because they've got to pay immigration lawyers, they've got to pay foreign recruiters, they've got to pay the fees associated with the government filings, that at least when we bring those foreign nationals in, they're right at the market wage. And I think if you took a survey of most practitioners in the immigration area who are seeing these wage calculations that are being provided by the Department of Labor, I think we would all agree that in most of the markets, per those industries, the wage is almost exactly spot on. I can't tell you how many times I've been involved in creating a strategy for an employer to bring in foreign talent. We receive the prevailing wage, and the prevailing wage is actually higher than the market wage. That actually is beneficial for United States workers as well. And that's because if an employer wants to participate in an H-1B program, they have to agree not only to provide that wage to that foreign talent, but they've got to agree to provide that wage for all similarly situated employees within that same category, which means that an employer is not only need to be prepared of the costs associated with immigration in order to hire foreign talent, but they need to be aware that asset that they're attempting to recruit may incrementally increase the wages of all workers within that category. And so immigration not only benefits the foreign talent, but also benefits the workers if the Department of Labor believes that those workers are receiving a less than market wage in that metropolitan area.
So there's prevailing wages, and then what other constraints are on the employer around how they design that job, and when they apply for a visa, what specifics about the job do they have to detail to the DOL? What kind of commitments do they make?
Well, part of the obligation is basically what the United States employer is promising to not only the Department of Labor, but also the Department of Homeland Security, is that they're not going to treat that foreign talent any differently with any sort of disadvantage over a United States or similarly situated United States worker. What that means is if I'm going to offer an opportunity, it's going to be a full-time opportunity. If I'm offering benefits to United States workers, I have to offer those same benefits to that foreign talent. If we're talking about PTO or some sort of other 401k benefit, those also have to be similarly provided to that foreign talent. Basically, the system is set up in a manner that an external observer of workers that are similarly situated should not see any sort of discriminatory treatment. People should not be desperately impacted by their employment with that employer. And so what that means is it's to the benefit of not only all of the United States workers, but also the foreign talent for an employer to participate in in immigration, in a robust immigration policy. What I can tell you is, beginning all the way back to the Clinton administration, riding through the Bush administration, through Obama, through Trump, and now with Biden, all 5 of those administrations really put a keen eye on whether employers were actually trying to take advantage of the foreign talent. Were we paying them less than similarly situated United States workers? And regardless of the political ideology, each administration had kind of an enforcement priority to examine how an employer treated their foreign talent and tried to ensure that they were similarly treated to all United States workers, regardless of that, wherever they were coming from on the political spectrum.
And how does any administration, how do they do that? How do they determine if this specific employer is breaking the rules? What are the enforcement mechanisms around that? So
actually, both the Department of Labor and the Department of Homeland Security have their own audit functions. So an employer who participates in a program that requires either a labor certification from the Department of Labor or, at the end of the day, a visa application with the Department of Homeland Security, basically exposes themselves to a compliance audit to ensure that if the Department of Labor or the Department of Homeland Security performed due diligence of that employer, that the employer was providing exactly what they said they were going to do when they petitioned for that opportunity to bring the foreign talent. It looks very similar to a fair labor standards audit. They're going to look at our payroll records. They may potentially interview our existing employees. If those interviews may not be limited to the foreign talent themselves, they're going to look at the benefits that paid. Did we provide uniforms? Did we provide tools? Were the employees responsible for their own transportations to the work sites? And if there is some evidence that there was a treatment, either we were treating the United States workers better than the foreign talent, or in some cases, we were treating the foreign talent better than the domestic workers, the United States and United States citizen and lawful permanent resident workers, then there is an enforcement mechanism where either wage and hour or fraud detection within the Department of Homeland Security can sanction an employer for failing to meet its obligations to its complete workforce, United States workers and foreign talent.
So as an employer, I have to demonstrate to DOL and USCIS that there is actually a need, and that I can't get labor for this specific position. But does it necessarily have to be a technical position, or are there visa opportunities for lower level jobs that you may just not be able to find somebody to do?
So we spent some time early in our visit discussing the H-1B, which is the most commonly used visa for employers who are bringing in what the Department of Labor has determined are high-skilled workers. So these are individuals who have either a bachelor's degree or, by virtue of their experience, the equivalence of a bachelor's degree in the United States. So that's your H-1B category. There's also an H-2B, H-2A category. The Department of Labor, I think, wrongly identifies them as unskilled labor because, for the most part, what they are is they're craft workers. They're individuals who, they're machinists, they're your pipe fitters, your welders, your rod busters, your concreters, who are every bit as skilled as a high-skilled worker. They just happen to work in an occupational category that requires what I believe are artisanal skills. And even in those categories, the employer is still required to test the local market, which means they've got to run an ad in an industry newspaper or the local newspaper of highest circulation to identify whether there are not United States citizens that are interested in landscaping opportunities or irrigation opportunities or harvesting apples, for example, in Washington State. And it's through not only the advertising, but also any sort of petition that goes to the Department of Labor in these unskilled categories also requires a job opportunity being posted with not only in the local workforce commission, so it'd be the Texas Workforce Commission in my neck of the woods, but any state workforce agency. There's also a posting of the same opportunity in what we refer to as Seasonal Jobs USA, which is a separate and apart, basically job opportunity clearinghouse that the Department of Labor runs off of their website as well. So not only are we advertising the opportunity via newspaper or via job posting with the state workforce agency, it's a global recruiting approach where they identify that we have an opportunity in Lockhart, Texas, for example, and anybody can apply for those opportunities. What I've seen, Mike, is probably what you're seeing amongst all of your clients, which is that we're in a real tough labor market. I don't know if it's a combination of the pandemic. I don't know if it is just we're losing all our baby boomers. They're all retiring. I don't know if it's because of a result of No Child Left Behind, where we decided that we wanted kids that were attending elementary school to be college ready when they graduated, as opposed to seeking out a vocation. I mean, when you and I were in high school, there was vocational school. If you decided as a sophomore, you know what, I really want to be an auto mechanic, you could have stopped your curriculum in high school and gone to work at a vocational school. you would be surprised at how well welders get paid in far west Texas. But I think like you and I provide services because our clients are having a pain point. They've got some sort of impediment to being the best they possibly can. I don't know if it's a combination of the fact that we no longer have vocational opportunities, or if it's pandemic related, or if it's the loss of a baby boomer generation. What I know is the pain point that our clients have in common is labor is impacting their ability to be as profitable as they want to be. Our clients are not coming to us because they want to abuse their employees. They're coming to us because they want us to assist them in advising them on how to cultivate productive workforces. If that means that we provide additional benefits, if it means that we give them, family leave, if it means 401k, if it means immigration benefits, they are seeking a workforce that will be as productive as possible, because each of our clients believes they have the greatest idea and they just need people to assist them in effectuating that idea.
And let's take a quick break. Good Morning HR is brought to you by Imperative, premium background checks with fast and friendly service. We've all heard the traditional advice when it comes to considering applicants' criminal history information. Look at it on a case-by-case basis. And for many employers, that's basically their policy, whether they've actually written it down or not. The problem with this approach is that it almost always is guaranteed to introduce bias into the hiring decision. This applicant went to the same school as I did, or I can really relate to his circumstances, so I feel more comfortable with his criminal history. But those aren't things that actually mitigate the risk someone may or may not pose in your organization, and they put you at risk of creating a disparate impact. To help create a more fair and robust system for evaluating the relevance of an applicant's criminal history, I've recorded a free webinar entitled How to Fairly and Legally Evaluate Applicants' Criminal History. In this 1-hour webinar, I cover the process of assessing the risks associated with a position and identifying what kinds of past behavior may be relevant to those risks. And this webinar is approved for an hour of recertification credit from both HRCI and SHRM. You can watch this and all of my other webinars on demand at imperativeinfo.com. If you're an HRCI or SHRM certified professional, this episode of Good Morning HR has been pre-approved for 1/2 hour of recertification credit. To obtain the recertification information, visit goodmorninghr.com and click on Recert Credits. Then select episode 69 and enter the keyword Lashus. That's LASHUS. And now back to my conversation with Kevin Lashus. Like you said, the unemployment has been nuts throughout. We shut everything down in 2020 and grinding the machine, ground the machine to a halt, and then getting everything fired back up. And for whatever reason, childcare, emotional turmoil, just not, finding work to be particularly enchanting or fulfilling for whatever. A lot of people just aren't coming back, and employers are having to figure out how to get the work done with what's available and look for other places where they can find that labor.
Absolutely. You'd be amazed how many calls I've been receiving during the last 6 months of an employer that said, we didn't think that we would ever be in the immigration business because
Right.
it's a cost. It's a sunk cost. It's an expense, but we just can't find somebody for this job.
So an employer invests in that H-1B visa or whatever visa program and legal fees, filings, all of that. Um, how long, when somebody gets a visa, can they, an employment related visa, how long can they actually stay?
Well, I really love this portion of my practice because as long as that employee is with the same employer, their immigration history will continue to evolve. So commonly when you receive an H-1B worker, that initial visa is good for 3 years. If that relationship is a good one and it's the right match, then a client will then ask for an extension, which is another 3 years. If during that 6 years we found a superstar, Mike, we want this guy to stay with us forever, then we'll take that next step and petition for them to receive an employment-based immigrant visa. Then using that immigrant visa, potentially that foreign national wants to stay here for as long as they possibly can. We will evolve that relationship towards a lawful permanent residency, or what people commonly refer to as a green card. And based upon that single non-immigrant visa application, that H-1B, eventually that foreign national can naturalize. They become a United States citizen. And not only that, but once they become a United States citizen, if they've got a foreign spouse or a foreign parent or a foreign child, they can then take the next step, which is, let's go ahead and leverage this, what was originally an employment relationship, into a familial or a unification relationship where we're bringing the parents into the United States as immigrants as well. So it is an opportunity. Our clients who have had relatively robust immigration strategies that involve petitioning for H-1B workers or H-2B workers or immigrant visas find it very endearing. And that's because these foreign nationals, they want to stay here. They want to stay here the rest of their lives for the most part. And in order to do that, they work their tail off and they follow the law. They don't drink and drive. They don't abuse their spouses. They don't do things that are illegal. And that's because they want that employer to take that next step. Have a little bit more faith in me. And, it's one more ask, but I'm worth it. Right. And so that's what is very fulfilling about an immigration practice.
Does an employer have to recertify the need for that labor when they renew that person in 3 years? So, I need, we had a shortage of nurses, or 3 years ago, but now there's a glut of them. Do I have to, as an employer, re-examine that, or can I just renew that and keep that person working for me?
If you're just extending a non-immigrant visa, you do not need to test the labor market. You are required to identify whether or not the salary that you will be paying during that extension is still a market salary, it's still a competitive salary, but you don't have to test the market. You will, though, have to test the market if you're converting that non-immigrant H-1B, for example, into a green card. You're going to have to go back to the Department of Labor and say, this H-1B superstar that I have, we're going to promote them into this position. And the Department of Labor is going to say, well, if you want them to stay with you permanently, we're going to have to test that market one more time. What I will tell you, though, is commonly, because of the characteristics that have been cultivated in that foreign talent, an employer can be really artistic about the job description to limit the potentiality of mass application for that opportunity. You're going to be able to identify that foreign talent has honed very, very specific skills. And so when you test that labor market the next time, you're going to be able to identify those skills that foreign talent has honed that very few other United States workers may be competitive in utilizing.
Because I have 3 or 6 years of experience working in your particular market on your
That's
particular
exactly
software applications and,
right.
and delivering your particular product. Okay.
Exactly.
That makes and that makes sense. Now, let's say I mentioned earlier. I think we're in a recession right now. I just don't think we're feeling it fully yet. But let's say we get into Q1 of 2023 and things slow down and employers start to talk about layoffs. Is there any preference when layoffs come versus, for domestic, U.S. citizens, employees versus visa employees? Do we have to give preference to, our own nationality before we do that?
When it comes to layoffs, you have to uniformly apply whatever approach you're going to take. Is it based on seniority? Is it based on productivity? Whatever assessment tool you utilize to identify which of the workforce you're going to lay off, it's going to have to be equally applied to not only your foreign talent, but also to your United States citizen talent. And that's because the immigration laws provide both the foreign national and your United States citizen to complain about the way that they were treated. A lot of folks focus on Section 274 of the Immigration Act because that's where the I-9 lives. That's where the employment verification function in 274A. In 274B is the immigration-related non-discrimination provisions. And a lot of employers are not aware that when they are assessing how they're going to either discipline or lay off United States workers or foreign talent, that they have to assess them with rose-colored glasses. They can't take the nationality or the citizenship of the employee into consideration when they assess who it is that they're going to lay off. So again, it's at that time when an employer is unfortunately considering layoffs that they should contact somebody who has experience with drafting and implementing a strategy to lay off employees in a very non-discriminatory fashion.
The Biden administration, we've got a couple years under our belt now, and there was a lot of talk about what was going to happen with immigration, with Democrats in control of the House and the Senate and the White House. Is there either on the legislative side or on the rulemaking side anything significant so far that's happened or that you anticipate anytime soon?
So one of the things that just recently occurred was, and I know you're pretty sensitive to it because you and I have discussed it, is that deferred action for certain alien foreign nationals that are current.
Yeah.
Exactly. DACA, so the DACA. So the Fifth Circuit Court of Appeals recently upheld a Texas federal court that opined that the Obama DACA provisions violated the Administrative Procedures Act. Now, what they did was, instead of compelling the administration to rescind DACA, what they did instead was they remanded the case to the original federal court to assess President Biden's recent rulemaking on DACA. So notwithstanding the fact that the Obama provisions have been invalidated by a lower court and affirmed by the Fifth Circuit, President Biden, I think, was very well aware that there were going to be challenges to the Obama version of DACA and went ahead and, through his executive authority, promulgated new rules. What the administration is doing now is they are really kind of putting both hands around their ability to implement immigration changes by executive order. I think the Biden administration learned quite a bit from the Trump administration and has been pretty aggressive about expanding immigration benefits to foreign nationals. We're seeing it with DACA. We're seeing it with temporary protected status. We're seeing it with the flexibility of the I-9 employment verification functions as it related to COVID and the examination of original documents, for example. The other thing that the Biden administration has been doing is significantly increasing the number of federal employees that are working for their agencies that support the immigration policy. So you're seeing a lot more being hired for the consular corps at all of the Department of State consulates throughout the world. You're seeing a lot more money for adjudicators at USCIS, national processing centers, and local processing centers. And I think what the Biden administration has realized is not only can they implement new immigration policy by executive order, but they can also streamline the processing both abroad and domestically if they're able to redirect resources to those ends. So at the end of the Trump administration and the beginning of the Biden administration, we're seeing processing times that have been exponentially increased. I know one of the issues you and I deal with all the time is we've got I-9 re-verification that we need to perform, but the employee does not have their EAD card or their lawful permanent resident card because of processing delays. And so the Biden administration has provided guidance to employers about being flexible about the re-verification requirements. But yes, you are right. I think the Biden administration has learned so much about being able to implement policy changes via executive order that we are going to increasingly see this administration attempting to legislate immigration reform through that Article 1 executive power.
And it's interesting because the administrative state is in a lot of ways one of the vampires I'd like to put a stake in the heart of personally. But
you're right.
You saw everybody complained when Obama did it, and then a whole different set of people complained when Trump did it, and now we've gone back to the original group of people complaining about the Biden administration. But sometimes maybe the ends justifies the means, and we just need to get some of this stuff just done and getting Congress. And it's, I think it's fair to say that while the Republicans get a lot of well-deserved at times beef about being anti-immigration, it's a lot of the Democrats' constituencies are pushing against additional immigration visas and stuff too, because they're protecting their own self-interest and
you're absolutely right.
And things like that.
You're absolutely right.
One last thing. So we get into a situation where, the pandemic happens and we realize, wow, we can work remote. And now a lot more companies are working remote more and more. Do you think that if things don't change, do you think just employers are going to start, more employers are going to either start working, become multinational employers and start, opening offices? I think the single largest country that H-1Bs come through is from India, I believe. Are we going to start opening more offices in India, and wherever else you can find the labor? Do you think that's going to be a result and maybe take some pain off the immigration system and just find more and more jobs abroad? And what do you think that'll do if that happens? What do you think that would do to the labor market here?
I agree with you entirely, but it's been happening, Mike, since 1996 when we had the economic boon that was kind of the shift to the tech economy. You had big employers like Microsoft and Oracle and Intel who had difficulty in petitioning for H-1B workers, and so they opened up shop in Dublin and in Vancouver and in Toronto. I think you're right. I think the pandemic has provided a window for opening up foreign offices that I think a bunch of domestic employers would have been a little bit myopic about, right? They would never ever conceived of having a situation where they had workers, that were remotely working in India and in South America and Australia and New Zealand. But I think the reality is, because we weathered the pandemic, the economy is only right now going through a recession because of a combination of, supply chain issues. We've got oil supply issues. We've got, obviously the political instability in Ukraine. But for the most part, I think a successful employer is going to look at every opportunity for them to grow. And if that opportunity is opening up an office in Berlin or in Milan or in Barcelona, I think they're a lot more open to it than they would have been 2 years ago.
Yeah, and the downside for the U.S. on that is That's tax revenue that we're losing.
You're right.
And we're not, we're not investing in people here in the country to build our brain trust and our next generation. I mean, people move here, they have kids here, the kids grow up in our school systems, they get educated. I mean, we need to continue to do that. And when we've offshored that stuff, I've got nothing against the offshoring. You got to do what you got to do to run your business. But I think our intransigence on dealing with the employment issues is going to hurt us long time.
Couldn't agree with you more.
Well, thank you for joining me today. That's all the time we have. I appreciate it, Kevin.
Absolutely, Mike. Anytime.
And thank you for listening. You can find previous episodes, show notes, and contact info for our guest at goodmorninghr.com or on Facebook, Instagram, or YouTube. And don't forget to follow us wherever you get your podcast. Rob Upchurch is our technical producer, and I'm Mike Coffey. As always, don't hesitate to reach out if I can be of service to you personally or professionally. I'll see you next week, and until then, be well, do good, and keep your chin up.